2018 County Commission meeting to do the zoning agenda. We have a quorum, so I'm going to call this meeting to order. And if we can take a few moments of silence here. Thank you. Thank you. Commissioner Smith?
Would you stand and pledge allegiance with me? I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
We have no consent agenda, and I was asked to read this to you guys. If you wish to speak on any item on the agenda, if you would please fill out a speaker card. Persons addressing the board shall have 5 minutes to complete his or her comments on each agenda item for which she or he has filled out a card. So if you'd like to speak, if you please go to the back and fill out one of those items. And I don't have any cards right now, so we're going to move, I guess, right into public hearings. Ms. Stirk?
Yeah. Thank you, Chair. I'll ask you guys to hear item 4M first. It accompanies item 4A and needs to be heard, and a motion needs to be taken on it before you hear item A. But I'll read both into the record because they're companion applications, and that way you can discuss them simultaneously and take separate action. So the first item, item 4M, is a public hearing requesting the adoption of the 2017-2.1 Comp Plan Amendment. And the item 4A is a change of zoning classification from PIP to RU215 from Imperial South. The property is 30.7 acres in size, located on the east side of Wickham Road in District 4. P&Z's recommendation was approval with a binding development plan.
Thank you, ma'am. I have one card on this item. Mr. Moya?
Hi, good evening, Commissioners. My name is Bruce Moya with MBB Engineering, representing the applicant. We're here tonight just to request that we get the future land use change as requested, and then item A is the rezoning to go with that future land use amendment that this would be the second reading for. Just a brief overview. I know the staff report was about 300 pages long, so I'll try to keep this real brief. We included all the provisions that were discussed with the neighboring properties where there was some concerns about the concrete plant that's across the railroad track. So all that's been put into the binding development plan as far as setbacks from the property, as far as buffers and walls. There was also some inclusion from some language from Commissioner Smith regarding having language in their written language when they go to do their leases and what they can or can't do as far as petitioning the commission for any grievances. So everything I think is included. If you have any questions, I'm just here to answer those questions.
Thank you, sir. Commissioner Tabaya?
Thank you, Madam Chair. I don't have a question. I just had a comment on this one. Are you ready for comments, Madam Chair?
I believe so.
Thank you. And I'd like to thank Commissioners Smith and Barfield for their leadership on this similar proposal that happened in March of 2016. What they pointed out was true, is still true today. Commissioner Smith pointed out as the county develops, industrial properties will still be needed. As a practical matter, it will be a lot more difficult to find land that can be rezoned industrial once these lands are developed. We have a plan for a reason. Quote, the county has planners that put these things on paper years in advance because they have looked at it and planned on how the county should grow, unquote. There's been a reduction of 86 acres in industrial zoning from January 2011 through March 2016 due to comp plan changes. Since this time, the county has had another net loss of 56 industrial zone acres. While the developers are now agreeing to put a buffer between residences at the plant, this does not affect the concerns with reducing availability of industrial property. Again, I want to thank the commissioners that came before that did their due diligence, and though there may be buffers with the cement or asphalt plant, it still doesn't deal with the need for industrial zoning that is decreasing, yet most likely will need to have more space as we move forward. Thank you, Madam Chair.
Thank you, sir. Good information. Any other commissioners have any comments? What's the pleasure of the board?
I'll make a motion to approve the adoption of the 2017-2-1 Comprehensive Plan Amendment Package.
I have a motion by Commissioner Isnardi. Do I have a second?
Second.
I have a second by Commissioner Smith. All in favor, say aye.
Aye.
Opposed?
Nay.
Passes 4-1 with Commissioner Tobias in opposition. Item B. Yes, you're right, 4A. You told me you would help me. Thank you. Ma'am, did you want to lead us into that again? Okay.
It's just for the change of zoning classification from PIP to RU250. Excuse me, it's for the change of zoning classification on for the same property from PIP to RU215.
Thank you, Commissioner.
With a binding development plan.
Thank you.
Okay. Any comments from the commission? Mr. Moya, did you want to speak to this again?
It's, no, basically the same thing, to answer any questions.
Thank you. What's the pleasure of the board?
I'll make a motion to approve.
I have a motion to approve by Commissioner Smith. Do I have a second?
Second.
Second by Commissioner Isnardi. All in favor, say aye.
Aye.
Opposed?
Nay.
Passes 4-1 with Commissioner Tobias in opposition. Thank you, sir.
Thank you.
Thank you. Congratulations. Item C? B. I can do this. B.
So item 4B is a request for a conditional use permit for a security mobile home and a fee waiver at Seminary Covenant Community Incorporated. The property is almost 3 acres in size and located in Merritt Island, and the P&Z recommendation was for approval. This property has a current code enforcement action pending on it. They are providing security to their property via an RV, which is what the code enforcement action is for, and they're attempting to solve that by locating a mobile home on the site.
Thank you, ma'am. Commissioner Barfield, this is your district, sir. Do you,
I don't have a problem with it. I don't see an issue with it. I looked at the property, and I think everything's okay, and I'm all right with it.
thank you, sir.
I'll make a motion that we approve the COP.
Okay, I have a motion by Commissioner Barfield. Do I have a second?
Second.
Second by Commissioner Smith. All in favor, say aye.
Aye.
Opposed? Passes 5-0. Thank you.
Thank you.
Oh, I didn't have to call roll. Okay, item C.
Item 4C is a request for a change of zoning classification from AU to RU111 by Donovan Homes LLC. The property is .83 acres in size, located off of Tropical Trail in Merritt Island. The P&Z's recommendation was interesting. They recommended denial, but they're seeking direction from the board regarding drainage issues.
Okay, and I do have about 5 cards on these. Ms. Rosinka, would you like to start?
I would.
Okay. Yes, ma'am.
Good evening, Chairman Pritchett, members of the County Commission. My name is Kim Rosenka. I am with the law firm of Cantwell and Goldman in Cocoa, Florida. I am here representing Donovan Homes LLC. With me is also Mr. Rob Donovan, if you have questions for him. This property is in Merritt Island, off of North Tropical Trail. I always get it backwards. And near Lucas Drive. The first page in the document is the information about the property. It's .83 acres according to the property appraiser's website. On it is a 1934 home that predates the county zoning code. It is a non-conforming lot of record. It's an AU zoning, and the zoning request would make it conforming. The second page in the packet is from your package. It's the zoning map. I just enlarged it. And as you'll notice, it's RU19 to the north of it. It's surrounded by RU111, and then further to the south is AU. I have on here the three individuals that spoke in opposition, Mr. Coe, Ms. Long, and Mr. Wyrick. They've spoken opposition at P&Z. I came into this after P&Z, just to let you know. The denial by P&Z was due to complaints by the neighbors of drainage. They requested direction, as stated by Ms. Sturck. I even put it on the front of my package here. I've never seen anything like that, somewhat unusual. Maybe you all have. Actually, Erin is shaking her head. Yes, it's unusual. There were a lot of concerns about flooding. You all know there have been concerns about flooding in North Merritt Island. In fact, there's been concerns about flooding almost everywhere in Merritt Island in 2017. Irma was unprecedented. We've had several other no-name storms. I have a client in South Merritt Estates that was flooded twice, 2 inches within 3 weeks in his house within 3 weeks of each flooding. So it is a problem that was just, I believe, unusual. And so it has raised concerns of flooding, and rightly so. As I said, the zoning and uses surrounding this property are consistent with what Donovan Homes is requesting, RU111 from AU. It was well explained in the staff report. Also, the recent rezoning last year of the lot to the north to RU19. RU111 is actually a better zoning, requires bigger lots, bigger house sizes from the RU19. I have in the packet for you also, there's a map of surveys, the third page, and that is the intended lot split. He does want to split the 0.83 acres into 2 lots, which would be permissible with an RU111 zoning. But I do have for you, and then in the next package, the next document is the property to the north, which was just rezoned last year with what's being done there and property information. It was 0.68. It's being split in 2 as well. So this is consistent with what's going on in the neighborhood. We've all always heard that when you develop land, you can't impact your neighbors. Your post-development drainage has to be the same as your pre-development drainage. And I've never known where that came from. So I researched the code. I talked with Joe Mayer, and he agreed that this was probably the best thing in the code that says it. It's section 22-48. It talks about the purpose and the intent of this code is to ensure new residential construction and additions provide for drainage of surface water away from structures to protect buildings from flooding. Requires a site drainage plan, subsection C, for all new residences. It must be accompanied by a site drainage plan meeting the minimum standards, must demonstrate surface water is diverted to the road right of way. And then the last page, which is 2 more pages of this section, a final survey is required to include the elevations to comply with the approved site drainage plan, and then the certificate of occupancy. The deviation or modification of the drainage system or failure to maintain the drainage system that results in the intrusion of water on adjacent properties shall be the responsibility of the property owner. This is to show you this is a building permit issue. Drainage is clearly a building permit issue, not a zoning issue. Also, too, for further protection of the neighbors, I have in here section 62-4032 and 4033 dealing with the duties of the building official to make sure the drainage plan is complied with and that any new construction meets all the requirements of the drainage. No building permit shall be issued unless the applicant for the permit first provides the proposed or estimated building slab, lowest floor elevation, and they'll be utilized by the building official to make sure they comply with the code. So again, this is a building permit issue. Under your administrative policies, which are at the beginning of your agenda packet, there are a number of policies that must be met for rezoning. Policy 3 is compatibility. It deals with hours of operation, lighting, odor, noise levels, traffic, and site activity. Whether it's consistent with emerging or existing patterns, which this certainly is. And then there's Administrative Policy 4, the character of the neighborhood. Again, looks at traffic, parking, trip generation, commercial activity, industrial activity in an established residential neighborhood. and Administrative Policy 5, whether adopted levels of service will be compromised. Your staff report shows that this is all met by this application, but what is clear is drainage is not in your administrative policies regarding rezoning. Also added to your agenda packet from the P&Z was the flood zone map of AE. I didn't know what that meant, so I provided the information to you, the last page of your document, what the AE zone is. It is worse than an X, but not as bad as some of the other ones, and it has certain requirements which the building official and the county staff will make sure that the drainage plan will meet. So I didn't know what it meant, and it's new in your package, so I thought I would include that as well. With that, we would request that you approve the rezoning from AU to RU 111 as it is consistent and compatible with what's in the neighborhood, and that the P&Z board did not really address the proper zoning criteria when they relied upon the drainage. And I also think maybe these codes would help P&Z understand how drainage is to be addressed. So, thank you. Any questions?
No, ma'am.
All right, thank you.
Thank you. Mr. Rob Donovan?
Just if you have questions, he's the owner.
Okay. Mr. William Coe?
Good evening. I'm William Coe. I'm a resident next door to where Mr. Donovan wants to build his new houses. Regardless of what the flood plan says, it was just mentioned a few minutes ago, the realities are different in that flood plan. The ditch back there in no way is built sufficiently to handle the water that it gets. Now, we can assume that we're going to get more of these storms. My home was, and I got a brand new home there, was within inches of being flooded. I submitted a disc rather late, I guess, because I didn't know I had to have it here 24 hours in advance. But I filmed this flood. And it's on this disc which these ladies possess over here. I guess they couldn't arrange for it to be put up, but it explains what I'm trying to tell you about this water. I was wading around in water up to my belt, and I'm at the road level. I mean, I'm 3.5 feet of water was sitting there. Now that ditch, until the county improves it and makes it do what it's intended to do, nothing's going to change. And eventually, if you build these new houses, we're going to get more water. And that may make up that little bit of inches that I didn't get wet with this last time, but I might the next time. Anyway, I just want to reiterate that there is a serious problem there. So, and that's all I really have to say.
Thank you, sir.
Thank you.
Thank you. Ms. DeLong?
Hello, I'm Misty Long. I live at 1030 North Tropical Trail. I've lived there for 20 years. Mr. Coe and his wife built a house in 2009, I believe. And I believe the standard then was he had to have his house 4 feet above road level. Now, I'm under that. If Mr. Donovan comes in and he has to put that much dirt and build a house, the water's going to go off in all directions, mostly to the east. Then after the ditch fills up, the only where that it has to go is back to the west and to the south. This last storm, I know it was a lot of water. With the rezoning, over on Lucas, there's 3 houses there now by the ditch. I was under the assumption that Mr. Donovan built all 3 of them, but he says he only built 1. So somebody else built 2 before him. The water used to sit on that property. Now that they've built a few houses there, and I went over there and looked, and to me, it looks like they put in some type of drainage that leads to the ditch. So instead of that water sitting on that property is now, as far as I can tell, diverted to the ditch. After the ditch fills up, which it's never empty, even when we don't have a lot of rain, after it fills up, the water moves up to the west, which Mr. and Mrs. Coe's house was more or less what we would call a moat, with water all the way around it, very high. The water moved up. I'm in front of them. The water moved up. Water went into my garage. It continued to move up, and by the time it stopped, it was about 10 to 15 feet at the most away from my drain field in my septic. We don't understand. There's nowhere for the water to go. There's nowhere on the front of North Tropical Trail. There's no pipes or anything to divert the water anywhere else. So it's going to continue to keep going into the ditch. I don't know how they're going to divert it anywhere else. Next time we have a big storm or a bad rain, my drain field and my septic can be ruined. I already had water into my garage this last storm. It's just, we don't understand. If he's got to add a lot of dirt, and not only that, but the property that he's going to split, I'm not sure how he's going to split it, but there's a house that sits there already. So I don't know if he's going to split it in half. If he does split it in half, I'm here. If he splits it in half and builds a house between this one and my house, and he adds that much dirt, he's going to be flooding out his own other house that he owns. I don't see that. I just don't see him. I don't see how that's going to work, you know. So I'm not sure exactly about what the laws are about how much dirt that you have to add. But if it's anything like Mr. and Mrs. Coe's, Mr. Coe and me and my neighbor to the south of me, he's below road level to the south of me, and we're all just going to keep getting more water. So I understand what his representative was saying about the zoning not being, the drainage is not a zoning issue. However, if that's all not fixed, then we all suffer. And Mr. Donovan also had the rezoning done on the corner of Lucas and North Tropical Trail, where he's built one house. His plans, I guess, to build another there. So this is, and where is that water? I know they say that, you know, when he builds it, that the water is going to be retained on that property. I can see that a little bit over on the Lucas side because the property is way lower. So if he added some dirt, but it's still going to move into the ditch. All the water is going to be diverted to the ditch, and then it's going to be diverted. When it moves up, it's going to move to the west up towards us and to the south towards my other neighbor. We just don't see how this problem is going to be fixed by the county as far as diverting the water. That's my issue, basically.
Thank you, ma'am.
Thank you.
Mr. Craig Wenrich?
Good evening. My name's Craig Wenrick. I live at 1020 North Tropical Trail, just pretty much adjacent to the property in question. I don't have to tell you about the flooding because they just got done telling you all that. So I've talked to an attorney, and apparently it's a civil issue. But all that water that comes onto my property is a form of trespassing. So I'm in the process of hiring a civil engineer. I have a surveying company, and I got to proceed that way because I was within a half inch of flooding. I had to wear boots to get out of my house. They're saying it's compatible with what's going on there, but you guys changed the zoning back in '07, '08, I don't know when it was previously. I've been there 40 years. We didn't have that problem until all these new houses started going up on Lucas, and now they just want to add more. And they're raising the property level with the new zone or codes, and it's going to put me underwater. That's that simple. So I don't know what you guys are going to do, but that drainage ditch has never been, I've never seen anybody out there trying to clean it in the 40 years that I've been there. That's all I got to say.
Thank you, sir. Okay. That's all the cards. Any comments from the commission? Mr. Donovan, did you want to come up and speak now, sir? Or? Okay. Commissioner Tabaya?
Thank you, Madam Chair, and I think this would be to staff. If I was reading it correctly, there would not need to be any type of comprehensive drainage plan since this was going from 1 unit to 2. My understanding would be if it was going to 3 units, there probably would need some engineering. Am I understanding that correctly?
That's correct. What requires the drainage analysis is a subdivision plan, and when a property is split into 3 or more lots, a subdivision is required. So splitting a lot 1 into 2 is exempt from the subdivision requirements, so therefore the only drainage that would typically be required would be with a single building permit and addressed with each building permit.
Madam Chair, to follow up.
Please.
Not a BDP, but is there any type of binding agreement that we could get for these folks to potentially move forward to find out if the flooding would potentially be allayed? If we had some sort of assurance that the remediation for that water would take place, and we had a survey to show that, then that, it seems like, would deal with the concerns of those surrounding houses. Is there a way that in the absence of splitting 3 that you could think that potentially we could do that with 2?
A binding development plan is purely voluntary from the applicant's standpoint. If the applicant wanted to volunteer, they could conceivably submit a comprehensive drainage study that included both of the lots or even perhaps all of the property they own, but that would be up to them because that's something that the code doesn't require.
Thank you.
Thank you. Commissioner Barfield?
I've gone and looked at the property. I go by it every day, going to the office. It appears to the east side of this property there is runs down, and it's pretty much wetlands, it looks like, in that area. I'd like to see some way where we can put a stipulation that there's a drainage study done on this, or I don't think it's unreasonable, and I think that would be something that needs to be done. We saw so much in this whole area. In fact, Lucas was blocked off because of a no-wake zone. And we had all Buttonwood down to the south part of that, too. We had a lot of flooding around there. And so I understand it's compatible, and because it's right next to it, but we need to look at a way where we can actually put a little bit more to this to make absolutely sure this is not going to tip it over the edge on flooding, make sure everything's okay. So I would recommend that if we could do a binding development plan, that we do that.
Should we ask the developer? Should we ask that from him?
Do you want to call up Mr. Donovan? Oh, Kim, of course.
I just have a question, because to me, your code covers that with a site drainage plan. It has all the requirements you're asking for, and he's certainly going to comply with code. He doesn't object to it, but this is something new that we don't know what would be in it. But correct me if I'm wrong, Ms. Reagan, doesn't or even Mr. Dunninghoff, Section 2248 with the site drainage plan required is dealing with the requirements of drainage for each individual lot. Isn't that correct?
Drainage with an individual lot as they come in with a permit.
Right, the site drainage plan. So I don't know how you would do that when the code already requires it, and he's going to meet each, I mean, there's
Okay, so
15 requirements.
So-
I guess a clarification would be the site drainage is not a drainage study as far as drainage calculations and storage based on calculations and that sort of thing. The site drainage with a building permit is more of a topographical review to verify that the drainage goes in the correct direction or stays on the property.
excuse me for just, I'm missing something here. What I want to know is, will this tell us that it could increase flooding? What study does it need, or what do we need to do to make sure?
They would need to submit a drainage study with drainage calculations, and maybe Mr. Denninghoff could clarify exactly what those drainage calculations do versus just a topographical plan, but.
Would you, sir?
A drainage study that would reveal or inform us as to what would take place there in terms of the flooding conditions would be a pretty extensive stormwater modeling effort, engineering effort, which would go well beyond what is ordinarily required associated with a single-family lot. However, this one is in an area that is that we know has a serious drainage issue. And so it would be a pretty extensive and expensive effort on the part of the property owner.
Thank you, sir. Commissioner Barfield, are you through? Commissioner Snarty?
I have a question, and that's sort of what I was kind of leading into. I think you were going to probably start to talk about that if I'd have prompted you to more. I mean, wouldn't it be doing an unfair burden on any resident requiring them to do an extensive, very expensive, comprehensive drainage study if we're basing it on new codes, say, that we've put in place to require the 4 feet of elevation or otherwise that may impact other properties? The thing that makes me a little bit nervous is that if we require this you either approve or you deny it based on its face, because I think if we start putting these kind of requirements, requiring an applicant to get an extensive drainage study, it's an unfair burden that we don't require of others. And I think just as a commission, we have to be a little careful, of course, weighing the fact that Merritt Island had a lot of water, but I can tell you dozens and dozens and dozens of residents and places where me and my staff have gone out where there's water and sewage in people's houses, not 10 inches or 2 feet from the door, but actually physically in their home. So I know it happened across the county. Now, if we can do more as far as that ditch goes, if we're not maintaining some of the drainage, maybe we could do better as a county. But I think to put this unfair burden on anybody, developer, individual, or otherwise, is not a fair burden, and I think it sets a bad precedent.
I can address a couple of things on that. In the case of the ditch, it's very little of the ditch is actually in public right-of-way or drainage right-of-way or easement, and the majority of it actually is not. And it's actually a slightly channelized wetland slough that is a geological feature of Merritt Island, which predates any development, and so it hasn't been on the inventory for the county to maintain, and so it doesn't surprise me that they haven't seen county forces in there doing maintenance work on that ditch. As to the burden, I think technically the property owner is required to demonstrate that they aren't going to have an impact if on adjacent properties or other properties, but historically and typically we have not required that extensive of an effort. I don't know if that changes the law with respect to that or there's an increasing level of concern about this sort of thing, given the frequency of flooding events that we've all been talking about.
Yes.
And also, too, this wouldn't really follow under zoning anyhow, correct? It would fall under permitting? I mean, it would follow under building?
That's correct. It would have to be done prior to a building permit.
Thank you. Commissioner Barfield?
I'd just like to get a legal opinion on this, since there is adjacent properties that are of this RU-1-11, that shows consistency, I assume.
Well, that is one of the things you consider, is compatibility with the surrounding area, the existing character of the land uses, the historic pattern of land use. All of those things are the primary considerations for a rezoning.
So if we would approve this, it still has to go through the building permit side, and we would see this again, or it would go straight to permits?
I'm sorry, would you repeat that?
If we would go ahead and do this zoning change, you would do the basic drainage plan or whatever that is. It's not the full-blown study. We wouldn't see this again. It would go straight through that.
That's correct. He would be allowed to go ahead and submit a building permit.
Now, what happens with that? I get them mixed up. Okay, drainage plan that they submit. What happens with that?
It's submitted with the building permit. We have a drainage engineer that would review the drainage plan that was submitted and approve it or ask for changes if need be, so that the property is graded in accordance with the plan that they provide with the building permit for the house.
Commissioners, if I may, the way the code reads with respect to a lot in this sort of condition, it would be required to demonstrate that they have a water treatment and a retention capability, which we don't normally have for single-family residential lots, but this one has no legal positive outfall associated with it, and so that would be a requirement. And we would impose that, and that does have a pretty elevated level of effort that's required to it. It's not as extensive as what I was describing previously, but it is a lot more than what would normally be required on a typical lot.
Will you say one more time the first part of that?
What we would be able to require,
okay,
because it does not have a legal positive outfall, is a treatment plan, a retention plan for the stormwater with sufficient calculations to demonstrate that they were not exceeding the discharge rates that are limited and associated with our code for the 100-year storm, and so that would put some controls on it. And what I was saying is that's a bigger effort than is normally required on a single-family lot. That does have a legal positive outfall, but it is not as extensive as what I was describing earlier, where they do a stormwater modeling of the whole area to examine what the impact would be throughout the whole drainage basin.
Thank you. Commissioner Barfield?
I think it's an old one. But based on that knowledge, I'm okay with it being, the zoning be changed. So I'll make a motion that we change the zoning classification from AU to RU-1-11, and that's my motion.
Second. I have a motion by Commissioner Barfield, a second by Commissioner Isnardi. All in favor say aye.
Aye.
Opposed? Passes 5-0. Thank you.
Madam Chair.
Yes, Commissioner Smith, sir.
I'm just wondering if we could request, because I know planning and zoning had a problem with this, if we could request I don't even know what I'm asking here, a summary of existing codes that address our administrative policy regarding drainage requirements so that they could refer to that? Is that something that we could?
Yes, staff could put together a summary for the Planning Commission so that they have some guidance in these situations.
Yeah, I think that would be most helpful. Do I need to make a motion for?
I don't think so.
For that?
No?
Or we can just request staff to do that?
Okay, we can do that.
Okay, excellent. Thank you.
Okay, we're at item D.
Yes, thank you, Chair. Item 4D is a request for a change of zoning classification from AU to EU1 by Frankie Jones, Jr. trustee, represented by Mr. Burial here today. The property is .454 acres in size, located on the south side of Jones Trail, just west of North Tropical Trail in the North Merritt Island area. It's interesting to note that North Merritt Island and the P&Z recommendations, they recommended approval for SR zoning. And I think Mr. Burial will speak to that.
Thank you. Mr. Burial.
Yes, ma'am. Good evening. And yes, my wife and I are purchasing this lot from my best friend's father to build our forever home. And after reviewing the first meeting we had with the North Merritt Island Homeowners Association, it did make a lot more sense to us that the SR was the more appropriate zoning than the EU. So when we came to the P&Z, we spoke to that and said absolutely we would concede to make that a change, and the P&Z agreed and recommended approval for it.
Thank you. So if we go ahead with this, you want us to make the motion to change it to the SR zoning?
Yeah.
I think if that's what you're interested, that's what you have to convey in the motion, yeah.
Thank you. Commissioner Barfield.
Yeah, I'd like a motion, I'd like to make a motion to change the zoning classification from AU to SR.
Second.
I have a motion and a second, but I do have one other card, and that is Mary Hilberg. Okay. Okay. So all in favor, say aye. Aye. Opposed? Passes 5-0. Thank you.
Thank you.
Okay, item 4E is a request for a change of zoning classification from RR1 and RRMH1 to AU by Werner R. Seiler, represented by Joyce Cole. The property is 7.2 acres in size, and it's located in MEMS, and the P&Z recommendation was for approval. The purpose of them seeking this request was to build a larger accessory structure on the site that is permitted in the AU zoning.
Thank you, ma'am. I don't have a card. Did you fill out a card?
No, I didn't. I just, if you...
I'm going to need
so
you to go
I
back
don't
and...
have to come up?
No.
Okay.
But if you want to fill out a card and speak, you're very welcome to.
I don't need to speak unless you have any questions.
Okay. This is in my district, and just so that you guys know, I'm comfortable with this. They're doing a down zoning. So, any comments, or can I entertain a motion to approve this?
I'll make a motion to approve.
I have a motion by Commissioner Isnardi. Do I have a second? Second by Commissioner Barfield. All in favor, say aye. 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 Passes 5-0. Congratulations. All right. Item F.
Item 4F is a request for a change of zoning classification from AU and RRMH1 to all AU by Tina G. Conover, represented by John Conover. The property is 2.13 acres in size, located in West Canaveral Groves, and the P&Z's recommendation was for approval. They currently have a code enforcement action that is pending that they are seeking to resolve via this rezoning.
Thank you. And you had mentioned to me that this was going to help with a few of these items moving
A few of the
forward,
issues
too.
with code enforcement. I think there will be a few remaining, but...
Well, we're working on them. I have a card here from Ms. Tina Conover and Scott Conover.
Why don't you get the code enforcement guy here so we can resolve it?
I'm sorry, sir. We're hearing this item here right now to help you move forward with your rezoning request.
And
Okay.
Madam Chair,
Yes,
we requested a summary of any of the issues with code enforcement. So if you have any questions about those
Okay.
issues, we can answer any of those questions. I guess if you want me to elaborate, I will.
Yeah.
Would you prefer I do?
Please.
Okay. The case that they have is for accessory structures without building permits. The property owners were cited and taken to a hearing for no permits for those things. They have built the structures across 2 parcels, so I think after they receive this rezoning, they're going to seek to combine those lots or take some action that would resolve those being across 2 property lines right now and resolve the permitting issue. So is that a good enough summary? Would you like me to go on about dates and things like that?
You know, this place has been here for 50 years. The code enforcement officer stopped there one day because the lady down the street called the police on me, called him because of the trailer I bought. I threw her son out. He was a dopehead. I threw her son out. So this guy come over, wanted to come into the place. I let him come in. Then he said, "Where did this place come from?" I said, "This place has been here for 50 years. He said, "When did you build the house?" I said, "How long you been a code enforcement officer?" He said, 3 months ago I got the job." I said, "Well, if you call the Florida Power and Light, the light's been here for 20 years. The water bill's been here for 20 years. The house has been there." Then he said, "How about the fence in the front?" I said, "The fence, look up your zoning board, and the fence was there for the last storm. They waived the permit. The county waived the permit for 3 months. I had animals." He said, one side of your lot is AU and the other side's residential. I said, I'm responsible for putting the metal on the roof of the pole barn, but it's been here for 35 years. It used to be a tomato packing plant on Barcelona, and the front of it was all one parcel. And he was taking pictures. I thought everything was, he never cited me, never gave us nothing. Whether he told you or he came to the last hearing, and we didn't hear nothing about all this. So, the idea is to get it resolved.
Yeah, and I think a lot of the issues that you speak to would be resolved. The AU zoning allows for
He said I wasn't allowed to have goats on the property. I said, "Put the goats in your truck and take them with you. I don't care about goats." And then he told me about you're allowed to have 4 chickens per acre. I had 10 chickens. The raccoon got the other chickens. So I got 4 chickens left.
With this rezoning, he would be allowed to have the goats anywhere.
Thank you. Can I'm new at this. Can I get you to read your name and address into the record for me real quick?
Read your name and address.
My name is Tina Conover, and it's 6751 Barcelona Avenue, Cocoa, and this is my husband, John Scott Conover.
Thank you. Sorry about your chickens.
And nobody ever fixes Satellite Road. I moved out there to get a hell away from people. I lived in a $1 million house in the Keys on the ocean, and I didn't want to deal with homeowners associations. So here comes this guy wanted to talk to me. So we let him in the compound, and he started taking pictures of whatever he could dig up and start with. The idea was the county needs to work on the road and work on the issues that they have out there. I have a lot of palm trees I put in my yard, and I get lime dust from crushed concrete all over my plants that kills my plants. And, it'd be nice if somebody would put a little effort into what goes on with these people. I'm not, the people are considered, the lady, your office, the lady told me that there's no taxes. Well, there's taxes in my house because I pay $4,400 a year for what? For a piece of land? The house is you knock it down as a $500 house. But if the problem is they don't pick up the trash, and they don't, and it's a rough road. The grader, you go look out, they spend more money on the grader going up and down Satellite Boulevard, grading the road out for people that come down 70 miles an hour, if they put millions or something down to keep the dust and level the road out. So that's whatever.
Thank you, sir. Did you guys want to change your property to AU, correct?
Oh, yeah.
Okay.
Yes.
I'm good with that.
One pole barn that spans the 2 lots. We've combined both lots now so that we can have this whole problem resolved.
I think it's a good idea. So can I entertain a motion from the
I'll make a
commission?
motion to change this classification to AU.
Second.
I have a motion by Commissioner Smith, a second by Commissioner Barfield. All in favor, say aye. Aye. Passes 5-0.
Okay, so all the code enforcement violations are over? Everybody? All the code enforcement violations? The guy
Madam
with
Chair, if I may.
Thank you, please.
The code enforcement violations that relate to the AU zoning, which would be your setback and your goats and chickens, those would be okay. There's still a process that you would have to go through to get the permits issued for the other structures. That's outside of this venue.
No other structures. There's no other structures.
You said there's a pole barn on the property, right?
Pole barn been there for 50 years.
Okay, so that's something we would have to look at. And you can, there's a, yes, sir.
Just, if you want, call the office tomorrow, and we will get right on everything, figuring out what we need to do next to help you all out.
Thank you.
You're welcome. Y'all have a good evening.
Yep.
Thank you. All right, item G, and you told me this item was tabled.
Item G has requested to automatically table the item, and they'll be tabled back to the date certain of the February 5th P&Z and the March 1st Board of County Commissioners meeting.
Okay, and so we'll move on to item H.
Do you have to make a motion?
Do we have to, no, they automatically tabled it. Yeah.
Item H is request for a conditional use permit for on-premises consumption of alcohol and for outdoor seating. We have Carmine Ferrero here. This is located in the Vieira Avenues, and I think the applicant can speak to the intent.
Thank you. Good evening, Chairman, fellow commissioners. Carmine Ferraro, Carmel Development, LLC, 3860 Curtis Boulevard, Suite 636, Cocoa, Florida. It's a pleasure to be standing in front of you again a second time on behalf of this applicant, Charlie Granger's restaurant chain. They are opening their second location at the Vieira Shops next to the Avenues, and we're here seeking the CUP for the service of alcohol, beer and wine with their food service. We received a unanimous recommendation from the P&Z. We had no objections, and we just ask you to support this and approve it tonight, and I'll answer any questions if you have them.
Thank you. Commissioner Smith?
I have no objections and I have no questions, and I will make a motion that we approve.
Second. I have a motion by Commissioner Smith, second by Commissioner Isnardi. All in favor, say aye.
Aye.
Aye. Opposed? Passes 5-0. Thank you, sir.
Thank you. Good evening.
Thank you. Okay, we have item I.
Item I is a request for an amendment to an existing binding development plan. This is by Mr. Powell Gary, or Powell Gary Services, Mr. Powell. The property is 2.79 acres in size and located on the south side of Broadway Boulevard, east of Industrial Drive in the Sharps area. The applicant is here today. He received a P&Z recommendation for denial, and I believe we have received a request to table the item, but I'll let him speak to that.
Okay, Mr. Powell.
Good evening. My name is Richard Powell. I live at 4745 Ivan Street in Port St. John. I'm about 4 minutes away from the property we're discussing. And that's part of the reason that I got it, was to have an industrial piece of property that I could put my things on. At the Planning and Zoning Board, when I went back to them the second time, I neglected to do one thing that they had told me to do, and that's to go back to the residents a second time and talk to each one of them. It's something that just, I can't explain it. It wasn't in my brain, and it didn't happen. I did do the other things that were recommended. I did made a change to the binding development plan. However, I believe that it still needs to be refined and restricted. I now have a concept drawing that I can present.
Great.
And so what I would like to do is to table it for me to, I did send out a letter to all the residents and set up 2 meetings last Friday and Saturday. No one came. They didn't come to the other meetings that I've had, but I have gone to their residents before, and I've talked to them on the phone, all except for one. And they're Canadian, but they have a representative that has talked to me. So I have spoken with them. There was only one gentleman that would not speak to me, I'm willing to talk to anybody and let them know what I'm doing. I want to be a good resident there. I want to put a piece of property there that enhances the value of there. And so I want the time to do that right.
Thank you,
So
sir.
I'm asking to be tabled for, I think the March is too soon, so it'll be your April meeting.
Okay, and just for disclosure, I've met with Mr. Powell, and I put that in our packet for everybody to know that I've spoke to you on this, because it's quasi-judicial. And I had recommended that you would go back and put some parameters in your plan so it would be easier to pass through, and I appreciate that you're making that effort too, sir. So I'd like to entertain a motion to table.
I make a motion, we table it
Madam
until the
Chair,
April meeting.
I think we need to make a motion to table to a date certain, and that date certain is April 5th.
Okay, I make a motion that we table this to April 5th.
I have a motion to table to April 5. Do I have a second?
Second.
Second by Commissioner Smith. All in favor, say aye.
Aye.
Opposed? Passes 5-0. We will see you here in a couple months.
Thank you much.
Thank you,
And
sir.
thanks for your service.
Thank you. Item J.
Yes, I'm going to do the same thing I did with M&A. These are companion applications, item 4J and item 4K. They're represented by the same attorney. So I'll just read them both into the record and then ask that you take separate action. Item J is a request for a small-scale comp plan amendment from residential 15 to community commercial by LTM Holding, represented by Kim Rozanka. The property is 2.42 acres in size, located at the north end of Dixie Highway, just west of US 1. In the Palm Shores area. And then the associated rezoning request is to go from GU to BU2 at the same location. And I should add that the P&Z's recommendation for both was for denial.
Thank you.
Good evening, Commissioner Pritchett, members of the County Commission. My name is Kim Rozanka. I'm here representing LTM of Florida Holdings, LLC. I'm with the law firm of Cantwell and Goldman in Cocoa, Florida. With me is Mr. Mattioli, the representative of the client, and Stuart Buchanan, the planning consultant. I'm here to ask first for a tabling of both of these items. It's unusual for me to do handouts for tabling, but I figured in this case you need to be well aware of the factors that are causing me to request this tabling. First, you'll see in the packet, we did request the tabling, and it was because the declaratory judgment action that you all had approved the county attorney filing on December 19th has yet to be filed. To my knowledge, we haven't been served if it has. And we are working with the county attorney's office to assist in that plan, but it's taking a bit of time. And the first 2 pages is the request to table, and Mr. Calkins' agreement that seems to make sense from his perspective. The third page in the packet is the second document. It's an email from Eden Bentley explaining all the things that have to be done for this lawsuit, and it is going to take a little bit of time, even though Mr. Knox thought it could be done in 6 months. And it still may be able to be done quickly, but we don't know yet. And then the second reason I'm requesting a tabling is because I did a public records request on January 9th. I just received over 500 pages of documents from the county on Tuesday, and I have not had the time to review all of them, and I don't have access to the attachments of the over 400 pages, almost 500 pages of emails. So I need to be able to get those documents as well. The third reason is I just also received the radius package with the public records request. And at P&Z, they suggested that we should have had formal meetings of all the homeowners because there were people that showed up from the subdivision to the south, which my client had not met with. And there's this misperception in the town that this is going to be 24,000 square feet of industrial use. And it's not. It's not at all. It's 24 1,000 square foot units that people can run businesses, store their things, store their lawn care equipment, things like that. So we do need to meet with all the residents because there is this misconception in I believe, a good part of the town. If you do not agree to table it, or even if you do agree to table it, and I know your habit is to allow people to speak, and I would just like the opportunity to cross-examine them if they do speak, and ask that they be put under oath. But I do request that you table. If not, I can go forward, but it would be much better if we can try to wait till we get to meet with the residents and I get all the information I need to present properly. Thank you.
I'm going to be open to table it.
Okay.
But like you said, you know, we have people that are here tonight, so I'm going to ask everybody, we have a lot of cards on this. understanding that this item is going to be tabled, which means there's going to be a lot of changes moving forward. If you're planning on being here at the next meeting when we hear the item, but if not, if this is the only night you can be here, I would love to entertain you to be able to come forward and to speak what you feel that you need to say. Ma'am, if you would, I'm sorry. No, ma'am, I'm sorry, hold on. What I'll do is I'll read the cards, and then you can let me know if you're wanting to come speak tonight or if you're wanting to wait to the night when we hear the item. I have Mr. Mark Matoli. You'll wait? Yeah, I'll wait. Okay. Stan Buchanan? Stu, I'm sorry. Thank you. Frank Falcon? You wait? Ed Washburn? Okay, sir, so you won't be able to make the next meeting? You want to? Yes, sir. If you'd state your name and address for the record, please.
My name is Ed Washburn, 3609 Bruno Circle, Melbourne. Appreciate the opportunity to speak. This has been going on since May the 8th of last year. The people that are here tonight have been coming out and coming out. Now, this is the precise way that you knock down the opposition, is it keeps getting drawn out, and people come, and then they say, I'm not going again. So I'm sure we'll all be here the next time, but I don't know how you're going to table to a date certain, because I don't know how Ms. Bentley is going to be able to tell you what date that it's going to occur, that they're going to have the suit done, but I'll let her address that.
Thank you, sir. Sharon Secord?
Good evening. My name is Sharon Secord, Town of Palm Shores.
Have your address, please. I'm sorry.
I'm sorry.
Your address?
163 Palm Circle, Palm Shores. The only thing we know about this proposed project is that it is storage facilities that will be rented out. It's wedged in between two housing developments. We don't know what the hours of operation will be. We don't know what restrictions will be, if any, on the renters. Aside from the noise, the traffic, I'm just opposed, seriously opposed to this, because we don't know what to expect and we haven't been given any details, aside from the size of the buildings. My main concern about this is child safety. Right now, our children are allowed to play. The only thing that will be separating our backyards from these storage facilities are our back fences. And these transient renters and customers will be coming and going right behind our houses. I just think it's not in our best interest to have this. I guess that's what all I have to say.
Thank you, ma'am.
All right.
Charles Chambliss?
Wait till next event.
Thank you, sir. Tim Woolwine? Lindsay Robinson? Okay. And Albert Benson? Okay. Ms. Aaron, if we do this, are we tabling these items separately, or should we go ahead and entertain the next information? Because I know once it's tabled, it's over, so I don't want to table until I'm done receiving public comment.
Yeah, you just need to, if you were going to move to table the item, you need to make separate motions on them individually.
Okay. Commissioner Smith?
Yeah, how come my button never works?
I don't,
I'll tell you that later.
you got here later than the rest of them.
I have a little problem with this because, and I understand Ms. Rosanka's concern with 500 pages or whatever it was, and it makes it difficult. But at the same time, we've got we've tabled this thing on May 8th last year, 7/10 last year, 11/6 last year, and now we're being asked to table it again. Can we not table this? If we don't table this now, is there a prejudice involved? I mean, can Ms. Rosanka just file another suit or whatever she wants to do? Can she bring this before us again? Is there, what arises here? I guess what I'm asking is, what happens here if we don't table it?
Well, I think she's done a couple of things. She has made a public records request with a lot of documents which may or may not be related. However, she did say that she's able to go forward today. The other thing that happens with multiple tablings is there can be due process issues that arise, but that would be an issue that would be related to whether or not other people could challenge the rezoning. So I think you have the freedom to move forward if you wish to, but you would need to hear from everyone who put in cards and hear from the applicant in full. You can't do it part way, because right now we're kind of mid-path.
Right.
Okay.
We have to read.
So then I have a question for Ms. Rosanka. If we can determine, Ms. Eden, can we determine when this court date is?
That is going to be very difficult. If you'll remember that Miller Cove discussion about the road and we couldn't determine the status, it is a very complicated issue. At the moment, we think there may be up to 20 defendants that we have to sue in order to join all the parties who might have an interest in that area. One of the things that is going on right now is Ms. Rosanka and her client are trying to see if they can get quitclaim deeds in favor of that corporation so that we can limit the number of defendants that will be in that lawsuit. The number of defendants can make the lawsuit last longer or be shorter. So that's a complicating factor. We have ordered a survey from our survey department. We are working at getting title work. We think we're probably a month away from being able to file at least, and then the other side has to answer, and then you have to have it scheduled for basically a trial. I think it's going to be well over 6 months, more like a year, before you have an answer. So I can't give you a date certain.
So what does that do for you if we're talking about a year from now? Because your client, he wants to do business, and from what I've been told, he does business there whether he's got a permit or not.
Well, you've been told improperly, Mr. Smith, that's not true. He's not doing any business from there, so that is incorrect. I believe if we go forward tonight, we will be prejudiced because we do not have all the records. We have not had the chance to inform the neighbors because there has been so many misrepresentations given. But we are prepared for a time certain, May 5th, and we will go forward on May 5th, whether this lawsuit is resolved or not. I know Ms. Bentley and Mr. Carl Bone, the town attorney, have talked about resolving their issues. I found that out from the public record, which I didn't know before. So there are things I'm learning in those public records that are actually, some of them are very surprising. So we will go forward on May 5th, whether we have this lawsuit resolved or not. But I really think if this is done properly, once the lawsuit's filed, we go into early mediation. And I think it could be done by May 5th. Mr. Knox sat here and told you in December it could be done in 6 months. That's about 6 months. So we will go forward on May 5th regardless, unless we're very close to resolving the road issue and you all feel that that's a good thing to do. But we'll be prepared. I just think that I will be prejudiced at this point if we go forward. I can go forward, but yes, you will wind up likely with a lawsuit, another lawsuit.
Ms. Bentley, do you want to weigh in on that?
Well, with the allegation of prejudice due to the lack of documents, I would say if you don't want to risk a lawsuit, then I would recommend tabling until May 5th.
Ms. Rosanka, but there's nothing happening on that property currently, correct?
There's no business being conducted. There's a fence that's going up according to a permit that's been issued by the county.
Okay.
And
So if we did wait, there's not going to be any harm done either way if...
No, ma'am.
Madam Chair, if I may, I believe the meeting that we're talking about tabling it to is May 3rd.
Oh, May 3rd.
Thank you. Commissioner Smith?
Well, if May 3rd works for you and May 3rd works for us, then I'm good with tabling it. In fact, I'll make a motion to table
Okay,
May
Commissioner...
3rd.
I have a motion. I'm going to let Commissioner Isnardi weigh in real quick if you don't mind, sir.
I'll second. And I would just say that, as as upset as some of the residents may be, we have somebody telling us to deny or to not table because, I know they don't like coming out here, but in actuality, I mean, where is the thought for the applicant who is sort of in limbo based on whether or not Miller Cove Road is a true road? So I think we have to be at least a little sympathetic to that and not just Ms. Rosenka's public records request, which I think probably have taken too long. I mean, we directed the county attorney to move forward to try to figure this out, and I think that we need to make sure that we're doing the right things as a county to figure out how to move forward with this, but I'm perfectly fine with tabling.
I have a motion and a second for a table. All in favor, say aye.
Aye.
Opposed? Passes 5-0. Item K.
You guys will need to make a similar motion for item K.
Just similar
To
motion.
the date certain.
I have more cards, though, so I'm going to run through the cards one more time before we table this item. Yeah, Kim Rosenka, Mark Matoli, Stu Buchanan, Ed Washburn, Frank Falcone, Sharon Secord, Charles Chambliss, Tim Woolman, Aaron Pitts. Thank you, sir. Lindsay Robinson. Thank you. And Albert Benson. Do I have a motion?
I'll make a motion to table 4K.
Motion by Commissioner
May
Smith
3rd.
to the May 3rd meeting. Do I have a second?
I'll second.
Have a second by Commissioner Isnardi. All in favor, say aye.
Aye.
Aye. Opposed? Passes 5-0. Thank you all for turning out. Item L.
Item L is a proposal for the removal of the binding development plan and conditional use permit on the Mangum and Baker property, represented by Mr. Harvey Baker, located off of King Street in Cocoa. The recommendation from P&Z was for approval, and we're very excited to have them back today. I think we have some good news he's going to share.
Thank you. And I do have 3 cards on this, and we're going to make sure that I have all 3 of you come up this time. And you are Mr. Baker?
I am Harvey Baker, 925 Westwood Drive, Merritt Island. Where we left this in December, pictures were submitted showing the junk cars and equipment from around the property removed. Y'all held it until tonight. My understanding was you wanted the opportunity for another code enforcement officer to come out and do another review before the final vote. So I don't know if that happened, so I'm submitting pictures to you tonight that I took 2 days ago on the 30th, and I'll just go through them briefly with you. The front of the building is, of course, the big building there was taken from 520. The building to the lot to the right is the west side of the building, but you see vehicles in the back. That doesn't belong to this property. That's the property next door. The next one shows a road headed east, which is going to the back field where the junk cars used to be stored. The one to the right of that is the partial field, which is grown up, which no cars. The one below that is just another shot of the field in the back. And then the last picture's shooting from the east back towards the building, showing the what I call the carport, the overhang area. So the junk cars, the equipment's gone. So with all that said, I would ask you to approve the removal of the binding development plan and conditional use permit, and to remove the code violation, please.
Thank you, sir. Steve Mangum? Mr. Mangum?
I'm Stephen Mangum.
I think that we've met every bit of the requirements that we hear, with the place being closed, the salvage yard gone, no business, no cars, no phones, no taxes, no no occupational license. The only thing I can do is just ask that you gentlemen, ladies and gentlemen, approve it and take the stipulation of the wall off so we can settle this matter.
Thank you, sir. Julian Mangum?
Thank you, Madam Commissioner.
If you wouldn't mind
My
to
name is
say-
Julian Mangum. Madam Chair, I'm sorry. My name is Julian Mangum. I reside at 7350 North Highway 1, Unit 102 in Cocoa, Florida. And to answer your question about whether or not the code enforcement, Mr. Baker's question about whether code enforcement came out, and I'm going to murder his name, and I apologize for that before, but I'm going to try. Mr. Dial Echevarria did come out with me on, I don't remember the exact date, but he did come out. He and I inspected the property together. He photographed the property, and he agreed that the problems that were causing the code violation had been resolved and that they're no longer there. So I also would ask this board to remove the binding development plan, the conditional use permit, and the zoning violation from the property and let it go back to its IU1 zoning so that we can move forward with our plans for the land.
Thank you, sir.
Any questions?
Commissioner Smith?
Yeah, I'd like to make a motion to remove the binding development plan and conditional use permit. But before I vote, I'd like to ask Ms. Bentley, I used to do business with these people. Am I supposed to disclose that beforehand, before I vote? Does
You
it
are
matter?
no longer doing business with them now. It was long in the past. I think you're okay then.
Okay.
Did
So
we treat you fairly?
you did.
All right.
I don't recognize this place, though.
Well, no, it was different when you did business, probably. This place has been in business there for about 50 years. And there were some issues earlier in the time frame where there were zoning problems then under a whole different regime. And those problems were solved, and there was actually a court order by one of the county judges that my father did actually have a right to be operating a salvage yard on that property, and he ordered the county to no longer remove him from that property and remove the county's, and I don't know what happened to it, we're looking over 50 years ago. And the business had been operating continuously since then without any involvement or complaint or issue with the county whatsoever. And then suddenly, because we wanted to, my father and mother passed away, we inherited the property, and we wanted to sell the property as a salvage yard. Suddenly, this 8-foot wall came out of nowhere at us as a condition for a conditional use permit to operate a salvage yard there, because the county suddenly says that it was never zoned properly for that. 50 years, and nobody in this county knew that it wasn't zoned properly for that. But anyway, that's water under the bridge. It's over now. The business is gone. The salvage yard is gone. And we just want to clean the place up and make it presentable and sell it or rent it to someone that can operate it in a fashion that is legally able to. And
Hey, I'd like to just tell you, as a teenager, I spent a lot of time at salvage yard getting parts so I could get my car running.
you're not the only one, sir.
Yeah.
Trust me.
And a lot of us did that back
You know,
then.
I actually retired and went back to work, and I had a lot of clients that I had seen before that have known me for many, many years. And when I walked into the place, they all asked me, Sid, what happened to Mangum's? It's been there since I was a child. My father bought parts from your dad and mom. You know, it hurts me. So. But like I said, water under the bridge, things change, time passes. We have to move forward and not look backwards.
Those are good memories from you.
Yes, sir, it is. Thank you. Thank you very much, Commissioners. I appreciate your time.
Thank you, sir. I have a motion and I have a second.
I'd like to ask the county attorney, is there a lien involved here, and do we have to dismiss that as well in my motion?
Is there any code enforcement lien?
There was code enforcement action. We have a code enforcement report in the file, which I'll provide. You can have my copy. And I think everything should be resolved after today.
Okay. Thank you.
All in favor, say aye.
Aye.
Aye. Opposed? Passes 5-0. Thank you, sir.
Can I ask who the seconder was, please?
Commissioner Barfield, you're welcome. And I believe that closes our public hearing portion. And we have no cards for public comment, and so we're going to move right into board reports. County Manager, Mr. Abate.
No reports.
Ms. Bentley.
No report.
Commissioner Barfield.
No report.
Commissioner Tabaya.
Thank you, Madam Chair. It appears that no actions being taken, substantive actions being taken, dealing with medical marijuana treatment centers. And I know we'd said till March, but I think we have a pretty clear indication that nothing's going to happen. And I know there was at least one, probably two other folks that are commissioners on this board that are interested. So I think it probably would behoove us to move forward one way or another prior to that date that we discussed. There literally are no bills, in the legislature that are moving. So I don't know who's going to be bringing it up forward, but please, let's leave it on our radar that it may come sooner than later.
Okay, I have been asking Tad some questions because I've still been asking questions about the pharmaceutical zoning, and they've been kicking some things back and forth with me. But are you guys ready to bring us any kind of presentation on that?
Yes, ma'am. Our plan is to bring that forward for the first reading on February 20th and then back to the board on March 6th. So I know that is a tight window, but that's what we're shooting for. We were waiting to see what was going to come out of legislation, and we've gotten down to that point. So there are some still a few questions out there. I was planning on setting up meetings with each of the commission districts to go through the final preparation and preparing that ordinance and then getting it tightened up and bringing it back to you all.
Okay, they kind of left us high and dry, huh?
Yeah.
No comment from you, right? Okay, Commissioner Smith.
No report.
Thank you, sir. Commissioner Isnardi.
No report.
And I also have no report, and I'll call this meeting adjourned.
The opinions expressed by any member of the public during any period of public comment do not necessarily reflect the views or opinions of the Board of County Commissioners of Brevard County, Florida, Space Coast Government Television, or the program sponsor, and are solely those of the presenter. The Board of County Commissioners of Brevard County, Florida, Space Coast Government Television, and the program sponsor hereby expressly disclaim any and all responsibility or liability for any defamatory or slanderous statements expressed by any member of the public during any such period.